Mr. President, Madam Vice President, members of the Court, it is an honor to address the Court, the principal judicial organ of the United Nations, on behalf of the Russian Federation. Today, we confront a crisis of legality and humanity in light of systematic undermining of the United Nations Relief and Works Agency for Palestine refugees by Israel and its negligence towards the overall obligations under international law, including those stemming from the status of Israel as an occupying power. The urgency of this matter cannot be overstated. Gaza balances on the brink of famine, hospitals lie in ruins, millions of Palestinians in the Strip, as well as in the West Bank, including East Jerusalem, face existential despair. Mr. President, the General Assembly's request for an advisory opinion, adopted by 137 states in Resolution 79/232, is based on Article 96 of the UN Charter and Article 65 of the ICJ Statute. These articles provide for the advisory jurisdiction of the Court. Some states, including Israel, in their written statements have argued that this request is politically charged, concerns bilateral relations, and the subject of the ongoing proceedings between South Africa and Israel on application of the Genocide Convention. This is not the first time the Court considers the relevant aspects of the conflict between Israel and Palestine. The Court's 2004 Wall Advisory Opinion and 2024 Opinion on the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem, established irrefutable precedents. In 2004, the Court affirmed that Israel's construction of the wall violated international humanitarian law. In 2024, it reaffirmed Israel's status as an occupying power in the Palestinian territory, including the Gaza Strip. These opinions constitute a solid foundation for facilitating peace in the region and ensuring the rights of Palestinians to self-determination, as well as providing for legal qualification of Israeli actions. They also serve as a basis for the present request of the United Nations General Assembly. Today, we address a new dimension: Israel's October 2024 laws banning UNRWA's operations, which, in our view, directly contravene the norms of IHL, the UN Charter, and the 1946 Convention on the Privileges and Immunities of the United Nations. Under Article 30 of the latter, disputes over its interpretation must be referred to this Court. Thus, the Russian Federation invites the Court to follow its own reasoning on jurisdiction and discretion to hear the present case used in 2024 advisory opinion, since the factual and legal background of these cases are quite similar. Besides, the question put before this Court is strictly legal. It concerns Israel's duties as an occupying power under IHL and its obligations to uphold the privileges and immunities of the UN agencies, other international organizations, and third states in and in relation to the occupied Palestinian territory. Therefore, we maintain that judicial restraint here would undermine the very architecture of international law. Mr. President, to understand the importance of this moment, we must reflect on history. Established in 1949 by General Assembly Resolution 302, UNRWA was created to address the catastrophic displacement of 750,000 Palestinians. Today, it serves 5 1.9 million Palestinian refugees across Gaza and West Bank, Jordan, Lebanon, and Syria. For 75 years, UNRWA has been more than just an aid agency. It is a symbol of international community's collective responsibility to the Palestinian people, striving for a state of their own, in exercise of their right to self-determination, in accordance with international law, and return. The role of UNRWA in facilitating the humanitarian aid is crucial, and its work is strongly supported by the vast majority of the international community. Agency's mandate, education, healthcare, and emergency relief is not mere charity. These spheres are legal obligations of the occupying power under ICJ. When Israel occupied Gaza and the West Bank in 1967, it inherited the duty to ensure the welfare of the population on the occupied territory. Instead, this responsibility was outsourced to UNRWA and other UN agencies and programs, relying on the agency's schools, clinics, and distribution networks to mitigate the humanitarian impact of Israel's own policies. In Gaza, as mentioned in the United Nations Security Council press statement of the 30th October 2024, UNRWA remains the backbone of all humanitarian response, and no organization can replace or substitute UNRWA's capacity and mandate to serve Palestinian refugees and civilians in urgent need of life-saving humanitarian assistance. Now, with the resumption of Israel's military operation in Gaza, together with the imposition of a total blockade since the 2nd of March, the Strip has continued to endure devastating destruction and a humanitarian catastrophe of unprecedented scale. The West Bank, where Israel has launched its full-scale military operation on the 21st January, risks repeating terrible Gaza scenario. UNRWA's installations and personnel are under attack there too, as well as in East Jerusalem, where after the enactment of the Knesset bills on the cessation of UNRWA's operations, all the offices, including the historic premises Sheikh Jarrah and Kalandia, operated since 1950, were arbitrarily closed. By doing so, Israel, for the first time in history, unilaterally prohibited the work of the United Nations Agency and deprived it of its privileges and immunities. It is also worth mentioning here that this year, UNRWA has been again nominated for the Nobel Peace Prize. Awarding this prize will obviously be timely and well-deserved, taking into account the highest price the agency has paid during the recent crisis in the Middle East. Israeli military operations claimed lives of 290 of UNRWA's staff members. To this effect, Russia has been consistently advocating for an unconditional and sustainable ceasefire, the release of all hostages and detainees, safe and unhindered humanitarian access, as well as the restart of the peace process on a universally recognized international legal basis with two-state solution formula at the center. Mr. President, it is the position of the Russian Federation, which is based entirely on the advisory opinions of the Court of 2004 and 2024, that Israel, as the occupying power, is bound by the ICJ, including the Fourth Geneva Convention and the Hague regulations. The Court observed in the Wall advisory opinion that in the 1967 armed conflict, Israel occupied the territory between the so-called Green Line and the former eastern boundary of Palestine under the British mandate, namely the West Bank and East Jerusalem. The situation since then has not improved, but rather deteriorated. According to the 2024 advisory opinion, Israel's withdrawal from Gaza Strip has not entirely released it of its obligations under the law of occupation. Therefore, Israel, to this day, remains an occupying power in terms of IHL, and its relevant rules and principles are fully applicable to Israel. We consider the following provisions of IHL as especially pertinent to the case in hand. Under Article 43 of the Hague Regulations, and I quote, "The occupant shall take all the measures in his power to restore, to ensure as far as possible, public order and safety." End of quote. Under the Court's interpretation in the opinion of 2024, this includes the duty to administer the territory for the benefit of the local population. Article 50, paragraph 1 of the Fourth Geneva Convention provides that the occupying power shall, with the cooperation of the national and local authorities, facilitate the proper working of all institutions devoted to the care and education of children. Article 55, paragraph 1 of the Fourth Geneva Convention further provides that, and I quote, "To the fullest extent of the means available to it, the occupying power has the duty of ensuring the food and medical supplies of the population. It should, in particular, bring in the necessary foodstuffs, medical stores, and other articles if the resources of the occupied territory are inadequate." End of quote. Article 56, paragraph 1 of the Fourth Geneva Convention provides that, and I quote, "The occupying power has the duty of ensuring and maintaining the medical and hospital establishments and services, public health, hygiene in the occupied territory." End of quote. Article 51 obliges Israel to facilitate humanitarian relief schemes by all the means at its disposal, if the whole or part of the population of an occupied territory is inadequately supplied. None of that is happening today. As stated in the UN Secretary General's press encounter on Gaza of the 8th of April 2025. Israel and its supporting states claim that other agencies can replace UNRWA, and the occupying power has discretion to determine whether, when, and to what extent other parties may be present and operate in the occupied Palestinian territory. We respectfully ask the Court not to follow this line of logic. Firstly, no organization possesses UNRWA's infrastructure in the Gaza Strip and the West Bank. 65 clinics, 12 food distribution centers in Gaza, and 30,000 local staff. Without UNRWA, Gaza's humanitarian system will collapse. And secondly, the mentioned before Article 59 of the Fourth Geneva Convention unequivocally obliges the occupying state to agree to the relief schemes on behalf of the said population. The Fourth Geneva Convention not only lays down that the occupying power must agree to the said relief schemes, but insists that it must facilitate them by all the means at its disposal. The occupation authorities must therefore cooperate wholeheartedly in the rapid and scrupulous execution of these schemes. Israel claims its laws on UNRWA are necessary for national security. Israel has the right to ensure its own security. But the path to this goal lies exclusively through a comprehensive Middle East settlement process and the realization of the legitimate right of Palestinians to their own state within the borders of 1967, with East Jerusalem as its capital. The right derives from one of the fundamental principles of the United Nations Charter, the right to self-determination of peoples. Even so, the security concerns do not absolve Israel from other norms of international law, including the norms on privileges and immunities of international organizations. Furthermore, the Fourth Geneva Convention in its Article 59 provides for safeguards that the relief consignments may be searched by the occupying power. UNRWA has cooperated with the Israeli authorities for decades, sharing staff lists, facilitating aid coordination, and conducting a thorough audit, the results of which are available to the public. We maintain that security issues should be subject to substantive cooperation and discussions between Israel and UNRWA to mitigate these concerns. Since the laws on the cessation of UNRWA operations also prohibit all contacts between Israel's government and UNRWA, the much-needed negotiations are stalled on the part of Israel. Given the crucial role UNRWA has played in over 75 years of its activities in the region on behalf of the Palestinians, the cessation of its operations will result in the catastrophic scarcity of supplies and assistance to population of the occupied Palestinian territory, including refugees in the neighboring countries, Jordan, Lebanon, and Syria. Israel's laws on the prohibition of the work of UNRWA will undoubtedly worsen the humanitarian situation in the occupied Palestinian territory and will make the population in the said territory inadequately supplied, the language used in Article 59 of the Fourth Geneva Convention. The role of the agency in providing complex assistance to the Palestinians is crucial to ensure their fundamental rights, including the cornerstone UN Charter right to self-determination, within the two-state solution framework. Mr. President, turning to the issues of privileges and immunities, the Russian Federation submits that UNRWA's legal status is clear. As a subsidiary organ of the General Assembly under Article 22 of the UN Charter, with a clear humanitarian mandate, it is entitled to privileges and immunities under the 1946 Convention. Furthermore, according to Article 105 of the United Nations Charter, the organization shall enjoy in the territory of each of its members such privileges and immunities as are necessary for the fulfillment of its purposes. Israel's October 2024 laws revoking UNRWA's immunities, criminalizing its staff, and seizing its assets constitute a violation of this framework. In no way do the provisions of the UN Convention of 1946 allow the unilateral revocation of privileges and immunities. The privileges and immunities of the United Nations play an important role in ensuring the functioning of this organization. They are necessary to fulfill the basic functions of the United Nations, such as maintaining peace and security, promoting international cooperation, and protecting human rights. Privileges and immunities allow the United Nations to carry out its activities freely, without fear of persecution by states or individuals. This ensures the independence and impartiality of the organization in carrying out its tasks. Israel's legislation is not merely unlawful, it is an attack on the UN fundamental principles. If tolerated, it sets a very dangerous precedent for states to dismantle any UN agency they deem inconvenient. Within the broader context of Arab-Israeli conflict, it is necessary to highlight that other UN structures, UNFIL and UNDOF in Lebanon and Syria, have also been negatively affected and obstructed by Israeli invasions and continued unlawful military presence. In a more broad context, United Nations and missions of states to the UN were also impacted. There were numerous violations by Biden and Obama administrations of the agreement regarding the headquarters of the United Nations of 1977 and the UN Convention of 1946. Part of the official premises of the Russian mission in the United Nations in New York was blocked. Issuance of visas of the state representatives for meetings under the auspices of the United Nations and of the UN staff members of specific nationality was deliberately hindered. Movement restrictions were put into effect. Similar violations regarding issuance of visas are committed by France as the host country of UNESCO. The erosion of privileges and immunities strikes at the heart of multilateralism, undermining the UN's capacities. Mr. President, Madam Vice President, members of the Court, this case transcends legal technicalities. UNRWA's collapse would not only doom millions of Palestinians, it would shatter the credibility of the UN system. Therefore, the Russian Federation respectfully submits the following. First, in our opinion, the Court has jurisdiction to give the advisory opinion requested by the General Assembly. Second, we believe that there are no compelling reasons for the Court to exercise its discretion not to consider the question posed by the General Assembly. Third, Israel, as the occupying power, has the obligation not to impede the Palestinian people from exercising its right to self-determination. Fourth, as the occupying power, Israel is obliged under ICJ to ensure and facilitate the unhindered provision of humanitarian aid and assistance to the Palestinian population. Fifth, due to the unique role of UNRWA in the occupied Palestinian territory, Israeli laws on the prohibition of the agency's activities violate ICJ norms and principles. Implementation of these laws will undoubtedly worsen the humanitarian situation for Palestinian population and significantly hinder the realization of the Palestinian people's right to self-determination. And sixth, by passing laws on UNRWA, Israel unilaterally deprives UNRWA of its privileges and immunities, which is a violation of the United Nations Charter and the Convention on Privileges and Immunities of the United Nations of 1946. Mr. President, Madam Vice President, members of the Court, let this Court's opinion be a beacon of hope, a reaffirmation that international law and not the so-called rules-based order governs actions of states and international organizations. Thank you for your attention.